Sam, welcome to Constitutional Chats, and we'd love it if you just want to tell us a little bit about the Eighth Amendment, some opening comments, and then we'll go to questions.
Sure. Well, thanks for having me, Kathy. I'm happy to talk about the Eighth Amendment anytime, and so it's great to have an excuse to do so. So yeah, I guess just to kind of dive in, I think I learned from you all earlier today that it's the shortest amendment, which I did not know. But rather than try to kind of memorize it, I pulled it up on my screen, and maybe we can just kind of start by reading the text. Basically says excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. So that's it. That's the Eighth Amendment. And I think something like 18 or 19 words, but there's a lot of history packed into it. And there's kind of a lot of important protections built into it as well, because at base, what the Eighth Amendment does is protect all of us against a really formidable power, which is the power of the government to punish us in a variety of ways, whether it's imprisoning us or taking our cash or our cars or our homes, or even killing us through executions. So I guess just to kind of rewind a few hundred years, this certainly isn't unique to the Eighth Amendment, but the Eighth Amendment is notable in that it's drawn almost verbatim from, I think it's called the English Declaration of Rights. It was passed in 1689, 88, in response to, I think, dethroning the Stuarts. Anyway, there's a lot of history there, and the Eighth Amendment really traces its heritage all the way back to the late 1600s. And it was a reaction to this really dangerous power of the crown to inflict these really terrifying punishments and sanctions on people. Even then, the people who were kind of forming this new government in England realized that it's really dangerous if the government can lock you up and throw away the key, or torture you, or take everything you own. And so, in putting together the written constitution in England, they decided to kind of create some kind of check on that power. And kind of that language kind of comes through the centuries, and we're still talking about it today, and the courts are still construing it. So I'm happy to kind of walk through the three different protections for a few minutes. We can kind of work backwards. I think most well-known of the three clauses in the Eighth Amendment is what's called the cruel and unusual punishments clause. The "and" in there is actually quite important. I think probably something only a lawyer or a judge would say. But the reason it's important is because the Supreme Court has said that in order to invoke the protections of the cruel and unusual punishments clause, someone who's targeted for some kind of punishment has to show that the punishment is not just cruel, but also unusual. So you see kind of a bunch of kind of weird case law arguing about whether, a kind of really debilitating punishment is unusual enough to count as a cruel and unusual punishment. Historically, this was used to kind of guard against, medieval punishments like hanging and drawing and quartering, and kind of like pick your gruesome execution. But in more modern decades, it really kind of does a lot of work in the context of modern day executions. Every year, you'll see Supreme Court decisions dealing with whether a particular kind of execution protocol violates the cruel and unusual punishments clause. You'll see cases about whether executing people who were minors when they committed crimes violates the cruel and unusual punishments clause, and things like that. Another area where, for years, folks have been trying to kind of push the envelope when it comes to cruel and unusual punishments is outside the realm of execution, which obviously is most important, most debilitating and serious punishment the government can impose, but also expand it into the length of prison terms. So, I guess getting put in prison is certainly not as maybe serious a sanction as getting killed by the government, but it is a serious infringement on your liberty. And so there's been a lot of litigation over the years over whether a prison term can be so long in comparison to the seriousness of your offense that too is cruel and unusual. And so one classic example from about 20 years ago involved a recidivism statute in California, a law that says if you commit 3 crimes, you go away for life, basically. And a guy kind of hit that third strike by stealing some golf clubs. And just based on that really low level of theft, he faced life imprisonment. And the argument there was, okay, we're not killing him, but we're putting him in jail for the rest of his life. Is that cruel and unusual punishment? And the Supreme Court said, no, it's not. So there's a lot that can be said about that. I will confess I don't litigate cruel and unusual punishment cases, but I'm happy to talk about it further. The part of the Eighth Amendment that I do the most work in, though, is the excessive fines clause, which really limits the government's power to punish you by taking your stuff. And so we see this clause come up a lot in the context of what's called civil forfeiture, which is an area that we do a lot of work in. And that's a series of laws where state, local, federal governments can take your cash or your home or your car, can take your property basically, based on the properties linked to a crime. And what's most concerning about civil forfeiture is that they can do that even if you and the homeowner, the car owner, haven't even been convicted of a crime. So one of the issues that we've been litigating is the extent to which the excessive fines clause prevents the government from basically taking everything you own to punish you for either a crime that you've committed or a crime that someone else has committed. The one thing I'll flag on the excessive fines front is that up until 2019, it wasn't clear that this clause protected against fines that are imposed by states and localities as opposed to the federal government. So it was clear that Congress or the DOJ, the Department of Justice, couldn't excessively fine you under the Eighth Amendment, but it was less clear if a state government could do it. So a case that we took up to the Supreme Court in 2019 clarified that yes, your local mayor, your local state attorney general, your local prosecutor, they can't take everything you own either under the Eighth Amendment. I guess we can touch briefly on the excessive bail clause. Like, I honestly don't have a whole lot to say about it. There's not a ton of litigation over the excessive bail clause. It's not even clear if it does apply to the states as opposed to just the federal government, although the Supreme Court has kind of assumed every now and again that it does. Kind of the one weird part of kind of bail law, which I know about and I will share because I think it's kind of weird, is that in Illinois, there's a system of bail, which is basically where you're arrested for a crime and you have to post a certain amount of money before trial to promise that you'll show up for trial, you won't abscond. And at least up until recently, and possibly still now in Illinois, the bail is set and you have to pay a certain amount of money, like can be tens of thousands of dollars, some of which is later returned to you, some of which isn't. Except if you live in Cook County in Chicago. And if you happen to live in Cook County and get arrested, then you get all of your bail money back except for $100. So it leads to this really weird dynamic where you can be committing the same crime, getting arrested under identical circumstances in Illinois. But if you're outside of Cook County limits, you might end up having to pay tens of thousands, hundreds of thousands of dollars that you're never going to get back. But if you happen to, get arrested within the city limits of Chicago, you do get most of that money back. So I honestly don't really know why it is that way, but it always struck me as kind of unusual. So yeah, I'm happy to talk about it more, but if y'all have any questions, I'm happy to kind of respond to those.
Well, thank you. That was a great summary. And, as we walk through these amendments in the Bill of Rights every week for the last several weeks now, one of the really interesting things we've learned is how the different amendments have been applied to the states and how some have not been applied to the states. And when you said it took until 2019 for the excessive fines portion of the Eighth Amendment to be applied to the states, that's really interesting. That must be the most recent portion of the Bill of Rights that was applied to the states, I would think.
So almost that's right. I think there was one more recently. It involved criminal juries and they're being required to be unanimous. But yeah, I think kind of the thrust of your point is absolutely right, which is that back in the 50s and 60s, every few years the court was incorporating different amendments, making clear that they prevented states and localities from violating your rights as well as the federal government. But just by happenstance, I think the excessive fines clause kind of fell through the cracks, and a couple of others also haven't been what's called incorporated. They haven't been held to apply to the states. So yeah, up until 2019, I think if you ask most people, they would assume that the excessive fines clause applied to all levels of government in the same way the First Amendment does, the same way the Second Amendment does as of 2010. But no, it wasn't until a case we brought involving a guy out of Indiana named Tyson Tims that Justice Ginsburg at the time wrote the opinion saying, yeah, the states can't excessively fine you just like the feds can't excessively fine you.
And I might point out, that was work that you all did at the Institute for Justice. Is that correct? I mean, you
Correct.
all took that case on, and it might not have had that outcome if you all hadn't taken that on.
Yeah, I mean, I don't know how much credit we can give ourselves, but we were privileged to represent Tyson, and we ended up ultimately getting his car back. He spent about 8 years trying to fight to get his car back through a forfeiture system.
Well, thank you for all the great work that y'all do there. I'm going to go ahead and turn it over to Tova.
Yeah, thank you. This was really fascinating. And it's so cool that you yourself have been the one doing the work on this issue. And just going back to Kathy's question about, the case, incorporating this amendment to the states. I mean, I just think that's really, really interesting. And, after the courts could you just, I guess, talk us more through the details of the case if you have time? And then also when it was decided that this was a right that would apply to the states, like how did that change laws in a lot of states? Like, have you seen states having to respond to that and changing their laws, or was it the case where like most states were already in line with what the amendment was?
Yeah, so a bit of both. I guess I'll respond to that second part first. But yeah, as I said, I think if most people thought about it, they kind of would assume that, the states can't, excessively fine you, even though the Supreme Court hasn't, strictly speaking, told us. So I don't think it was kind of a sea change in that regard. But I do think it was important in that it kind of raised the profile of this, sometimes forgotten part of the Eighth Amendment. As I said, the cruel and unusual punishment clause, gets a lot of play, understandably, kind of every term of the Supreme Court. But Tyson Tims's case, the one that we're talking about, that was the first excessive fines case that the Supreme Court had taken since, I think, 1999. And over our entire nation's history, the Supreme Court's heard an excessive fines case, I think, only 4 times in total. So it really has been overlooked, I think, in a way that's unfortunate. And one of the many benefits of our litigating Tyson Tims's case up at the Supreme Court was not just that we clarified this question of incorporation, but that we kind of got the excessive fines clause back in the map in a way. I think that was only compounded by the fact that once Tyson's case continued back in the Indiana Supreme Court, we ultimately ended up winning, and the Indiana court really did announce a view of the excessive fines clause that protects people who are low income from these kinds of debilitating economic sanctions, and that we hope can be kind of transported to other courts around the nation.
Wow, it's fascinating. And then, I also wanted to ask, about like I guess a more obvious question about like the idea of an excessive fine. Like, I guess more generally, when there are these, well, I guess more general phrases in the Constitution, how do the courts go about like quantifying and defining that, especially when like inflation, changes so rapidly at a pace that the courts might not be able to keep up with? Like, I guess what's the process of defining a more broad term like that under the law?
Yeah, I mean, I think it's certainly challenging for the reason that you suggest, right? Like, how do you translate a word like excessive to dollars and cents in any particular case? I think courts struggle with that, and the way it ultimately plays out is kind of on a case-by-case basis, where you get data points from past cases. So in the Tyson Tims case, for example, he had a $35,000 Land Rover that was seized, and they tried to forfeit it because he committed a low-level drug crime. He also was very poor at the time. And so kind of seizing his most valuable asset, seizing his kind of way of getting to work, way of getting to drug treatment, that would have had a debilitating effect on his recovery and his reintegration into society, kind of beyond the dollars and cents value of the car. So kind of on that really kind of fact-specific set of circumstances, the court felt comfortable saying, yeah, well, there might be close calls at the margins here, but this seems like an excessive fine. There's just such a mismatch, right, between the crime, this low-level drug crime, and the punishment. Taking this low-income guy's, this low-income recovering addict's most valuable asset, 8 years after he was arrested. Now, of course, right, as you suggested, that doesn't solve, every excessive fines question for all time. But kind of going forward, you'll kind of get more cases like that. You'll get cases where the courts say, well, that was a really bad guy and the fine wasn't that big, so it's not excessive. And so you kind of basically get a spectrum, I think, that you can draw on. And that in part, I think, is why we're kind of excited about Tyson's case as well, because it does provide a really useful data point that other courts can look to.
Yeah, absolutely. Setting a precedent is a great thing for future cases, as you said. But I was also curious, like in your case, how the idea of a fine, which is like the language in the amendment, differs from like, I assume the police maybe said, oh, this is a confiscation of property versus like a fine being imposed. Was that a difference you had to reckon with, or, was that anything brought up?
Yeah, so to a degree in Tyson's case, it was, but it continues to be kind of a pressure point when it comes to excessive fines. The Supreme Court back in the 90s made clear that, okay, fine doesn't just mean something that happens to be labeled fine in a criminal court action, right? Like the government can't circumvent, the excessive fines clause that easily. So what the court basically said was, just as a common sense matter, if the government's taking your stuff to punish you for something, that's probably going to be a fine. It doesn't mean it's excessive, but it means we're at least kind of asking whether it's excessive. Now that was like 25 years ago, but the governments continue to try to kind of wiggle out of that constraint. And I'll give you one example, which is another case that we have involving an 82-year-old grandmother who lives in just outside Boston. So she was fined about $2.1 million by the federal government because she failed to file a one-page form with the IRS. And she's been fighting that case for the past 9 or 10 years or so. And she's raised the excessive fines clause as a defense, basically saying, I didn't really know what I was doing. I filled out my tax forms by hand. You hit me with this enormous, debilitating fine. And what the federal court in Boston said was, well, that's not really a fine, it's a civil penalty. So we're not even going to consider whether it's excessive to take this enormous chunk of cash from you. So that, I think, is an example of where you see the government trying to kind of get out of even, whatever constraints the excessive fines clause might impose by trying to kind of recast something that's obviously punitive, that's, obviously a monetary sanction, as something other than a fine. So we've asked the U.S. Supreme Court to take that case up as well. We should be hearing whether they'll take it sometime in January.
Wow. And then so going, as you were saying, the idea of forfeiture, I'm just very interested in this. The older I get, now that I'm an adult, I'm like, wow, the government can do all these things I did not know that they could do. So forfeiture is the idea of it. At least what the government says it's for, is that for a security reason? This is a crime scene and we need to take the property to investigate it? Or is it literally just as a mechanism of punishment? You committed a crime, so we're gonna take your thing as punishment.
Yeah, that's a good question. It's definitely the latter more than the former. There's, the government kind of can take stuff for evidence, obviously no one really disputes they have the power to do that, but the important thing is that after trial they have to typically give the evidence back to the person who owns it. But when we talk about civil forfeiture, we're talking about the government kind of permanently divesting you of your property, whether that's currency or an Xbox or your home, to punish you for either committing a crime or for letting your property be used to commit a crime, whether or not you did it, sometimes whether or not you even knew about the crime being committed, whether or not you should have known it was going to be committed. And it really is, frankly, one of the most kind of dangerous threats to property rights, I think, in the nation today. Most states have a system of civil forfeiture. The federal government has a system of civil forfeiture. And in many ways, it kind of turns on its head some of the basic premises of our justice system, right? When you think about the criminal justice system, for example, you think about that, you're innocent until proven guilty. Right? That's kind of like a bedrock principle that we all kind of assume is how the system is supposed to work. But when it comes to civil forfeiture, oftentimes, the burden is on the homeowner or the car owner to prove their own innocence. So it's enough for the government to come in and show by a pretty low standard of proof that, oh, well, your car was used in a drug crime, for example. And then you have to hire your own lawyer. You don't get a free lawyer. And you have to come in and prove that you didn't commit the crime yourself. Maybe it was, your spouse, or that you didn't even know the crime was going to be committed, that you shouldn't have known the crime was going to be committed. And so that's just one example of how this system really is kind of this topsy-turvy world where the government is kind of punishing people for crimes they might not have committed. They're flipping the burden of proof. And kind of to top it all off, what often happens is that the very same police departments and prosecutors' offices that decide whether to forfeit your currency stand to profit from doing so. So the money goes right back to those same agencies, can go to salaries, can go to benefits. And so there's this really built-in incentive for law enforcement to take as much as they can, which in part is kind of why we have an excessive fines clause to begin with, to kind of act as a check on that incentive.
I see. And then going on, I guess moving to another topic, you mentioned towards the end about the bail system, the cash bail system. And I'm, from Illinois, so I've heard a bit about there's this, in our state and in a lot of other states, there's the debate going on about whether cash bail even is a good system to have people, have to put up money and then do wealthier people benefit from the system. And there's now discussions about moving away from a cash bail system to maybe a system where a judge rules based on your risk of, going, failing to appear in court, whatever. So I'm curious about your take on these debates and then how they might relate legally to the Eighth Amendment, or if, advocates on either side have looked towards this amendment as, a proponent for their side.
Yeah, so I'll preface it by saying like we don't do excessive bail work. So like, I am by no means an expert on excessive bail, but I can kind of give you my sense of kind of what the contours of the arguments are, which I think you articulated pretty well. There does seem to be an increasing move to eliminate cash bail. And by that, right, we mean, someone's arrested, might be a year before they go to trial. Do we keep them in jail that entire time, or do we let them out and about and live their lives? Because right, they're presumed innocent until they're proven guilty. I think, a lot of the kind of pushback on the idea of eliminating cash bail suggests that, well, it means we're going to let dangerous criminals go free. Maybe that is the case in certain instances, but I think generally the response to that is that, no, when we're talking about eliminating cash bail, we're not saying, everybody goes free without consideration of whether, they're likely to abscond, whether they are a danger to their community. The court, as you said, is supposed to engage in that analysis. But kind of the dispositive factor shouldn't be, is this someone who happens to have enough money that they can get out of jail? Critics say that that's basically equivalent to a debtor's prison, where, you have two identical people who are pose the same danger to the community, have committed materially similar crimes. If one person can afford the thousands of dollars for bail, they get to go out and live their lives. If someone is poor, they don't. And there is, I think, a disparity that a lot of people rightfully find troubling about that.
Yeah, thank you for articulating that. And then my last question, I know I've been asking a lot, but it's such a fascinating topic. You mentioned, sort of alluded to how this amendment was drawn pretty directly from the English Declaration of Rights. So I was wondering if you could talk a little bit more about the history of the source of where that came from. And then, are there other amendments to your knowledge that were sort of drawn pretty directly from other sources, or is the Eighth Amendment unique in that sense?
That's a pop quiz, and I might get the answer wrong to some of that.
Put you on the spot.
So I can safely say that I'm pretty sure that some of the other amendments are drawn from the Declaration of Rights. I think maybe the First Amendment, right, free speech, free religion, or freedom of exercise of religion. The search and seizure one, the Fourth Amendment, I think, but I may be wrong about that. But kind of more broadly on the history, basically what happened in the 1600s, not to get too deep in the weeds, was you had the Stuart kings, who were pretty notorious for abusing what we would now call the criminal justice system, oftentimes for private or institutional gain. So you had what was called the Star Chamber, which was like this famous secret court where people would go in and would get tortured. And you had situations where the Stuarts, the kings, and their allies were imposing these crippling fines on people for really kind of minor offenses. The goal being, one, to punish their political adversaries, or two, just to make money for the crown without having to go through the legislature, without having to go through parliament. So there was just a lot of concern once the Stuarts got deposed the second time, I guess it was. A lot of concern that we don't want the government to have these really formidable powers over our daily lives, over our property, over our liberty, without putting some kind of check on their instinct to abuse that power, whether it's for personal gain or institutional gain or what have you. And so that, I think, was kind of the impetus for whatever the predecessor to the Eighth Amendment was. Some of the folks who drafted the Declaration of Rights had themselves been imprisoned, for example, by James II. There were really high-profile instances of these kind of cartoonishly malevolent judges, imposing these debilitating sanctions on people. That was very fresh in everyone's mind, and it just kind of became, this basic principle of, a free society that the colonists brought over to America when they kind of were traveling over to what became the United States in the late 1600s, early 1700s.
Well, thank you so much. I know I've taken up my share of the time, but you did a really great job of explaining everything. And, thank you for all the work you do on this. And now I would love to pass to Jewel and Jordan.
Thank you.
Thank you for the cool show so far. I know I came in a little late. There was some link issues, so I may have missed some stuff, but I got to hear a lot. So I take it you actually bring some cases regarding the Eighth Amendment to court?
Yeah, that's exactly right. As I was saying, we don't get involved in cruel and unusual punishments cases like the classic kind of like death penalty litigation. But a lot of our cases involve the excessive fines clause, right? The government's power to punish you by taking your property. And that's kind of where our area of focus is.
So being as you get to see this, then do you think that without the Eighth Amendment, that this would be a hugely like this would just be a massive problem of the government constantly abusing the citizens if they didn't have this check in the Eighth Amendment?
Yeah, I mean, frankly, I think it is a problem, even with the Eighth Amendment. The courts have construed the excessive fines clause to place a relatively high bar before they're going to say that police and prosecutors have gone too far when they're imposing fines or forfeitures on people. So there's a lot of room for the criminal justice system to abuse people through taking their property. The excessive fine clause is an important kind of backstop on the worst excesses there, but it certainly isn't a cure-all. And just to give you kind of an example, I can point you to another one of our cases, which is out of a little town called Brookside, Alabama. It's a very small town. Over the past few years, it basically came to rely almost exclusively or very heavily on traffic fines. And so they were pulling over an enormous number of people on a daily basis, with the avowed goal not of doing justice or making sure that people are driving safely, but just padding their budget so that they could churn more money back into their police department. And that's not how we want police officers deciding how to enforce the law. Now, the excessive fines clause certainly, as I said, can act as a check on some of the worst of those examples, but there's still a lot of room for the criminal justice system to take people's stuff and impose all sorts of consequences on them that follow from that.
Is there any other piece of law, particularly that is also that a foundational backbone that you're able to use in litigation when you're seeking to protect someone from this, or is it that backstop the Eighth Amendment really all there is?
No, so I mean, one of the other parts of the Constitution that we use, I don't want to skip ahead 6 amendments, but is the 14th Amendment's due process clause. So back in the early 80s, the U.S. Supreme Court said that there might be situations where a prosecutor, for example, has such a kind of a personal financial interest in imposing a fine on somebody that it's distorting their discretion, distorting their prosecutorial power, and that violates the due process clause. So we brought several cases kind of making the point that when we're talking about civil forfeiture, for example, when we're talking about that example in Brookside, Alabama, where clearly the driving force is not doing justice, but making money, that so distorts the criminal justice system that we're going to say it's a violation of due process. Some courts have agreed with us. We had a victory in federal court in New Mexico a few years ago. Some courts have disagreed with us. So that's an issue that's kind of percolating through the courts.
And then as far as the I guess the difference between the spirit and the letter of the law here, when we're talking about the fine itself, are we looking for, is the law seeing that as something which is to make up for the damage done by this individual, or is it a moral penalty to pay a debt for what you've done, or is it both?
Yeah, no, that's a great question. It's kind of a tricky one, because I think the answer is that oftentimes when we talk about fines or forfeitures or that kind of thing, like punitive economic sanctions, like it's kind of a bit of both, right? It's a bit of a hodgepodge. The idea is that, okay, maybe some of that money will go to conceivably go to recompense the police department for their costs, but also, right, we want to punish this person. So it's not just it's not as easy as you stole $5, we're to make you pay back $5. You might have to do that. That's called restitution. But the fine is meant to kind of have that kind of moral sting as well. And to be clear, that doesn't necessarily make it unconstitutional, right? Like the governments can constitutionally punish us if we violate laws. But what the Eighth Amendment really does is say, yeah, they can, but there are limits. You kind of can't go too far. You can't take everything somebody owns because they rolled through a stop sign, for example. You can't execute someone because they, stole $5. And so that's really where the Eighth Amendment really, I think, does the most work, is checking kind of those outlier penalties.
Is it, and then when you had said about how that in that one case the government was trying to use it as I think you used the word penalty instead of fine, as a way to get out of, as a way to like save themselves. So I guess my question there is that in the way that the amendment is written and in the meaning of the time and era it was written, would See, for me, I would interpret it as fine means any forfeiture from the government, whether it's even if it's a civil forfeiture, the way it's happening today. Basically, anytime that a person who is, or not a person, but a government entity is removing property from you is some form of fine. So how could the government then, so how is that wrong, I guess, in the way that modern law is practiced, that they're able to call something a penalty instead of a fine?
Yeah, so I mean, the short answer is, I think you're exactly right, and it's the government who's wrong when they say that, because I think your instinct is spot on. The idea that the government can't just slap a more benign label on it and say, well, this is a not fine, and therefore we can take everything you own, right? It's not that easy to, it shouldn't be that easy to circumvent any part of the Constitution. And indeed, the Supreme Court has said that kind of as an original matter, when the framers used the word fine, they weren't talking in like a narrow sense about like a certain specific kind of economic sanction. Now, the government continues to try to push the envelope here as elsewhere and try to kind of maximize its power to take the most stuff with the least amount of oversight. And that's, I think, why you see various governments kind of trying, as I said, trying to push the envelope and kind of reduce the protections of the excessive fines clause as much as possible through basically an exercise in wordplay.
Yeah, it's kind of scary almost when you think about how far that could go. Then, do you know who, when we're talking about these individual instances, and it's almost like I'm having trouble understanding who in each situation would actually be the official making this choice, when we're not talking about a judge who's making a conviction, but we're talking about an individual like an FBI agent or an IRS agent, or who is this they who would be choosing that, okay, grandma, you have to pay 2.1, or you, sir, I'm going to forfeit your Land Rover, $35,000 Land Rover.
Yeah, no, that's a great question. And I mean, it kind of depends on the specific, fine or forfeiture we're talking about. Certainly there are many situations where the fine is set by the judge, where a statute says, I don't know, if you rob a store, you can go to jail for up to 5 years and pay a fine of up to $50,000, and you're sentenced, and the judge says, okay, well, you seem like you're an okay guy, you get a $5,000 fine, not a $50,000 fine. There's some discretion built into the judicial system there. But oftentimes in the examples you alluded to, the court doesn't have a ton of discretion to kind of balance the equity. So in the case of our client who got the $2.1 million fine, that really was a decision made by largely unaccountable IRS officials. And then when she didn't pay, they then sued her in federal court basically to collect, and she had to raise the excessive fines clause as a defense. In the context of civil forfeiture, like the car that Tyson Tims owned, it's a judicial process. There's a court entering orders, but the courts typically don't have a ton of discretion to say, well, taking the whole car is too much, so you can take half the value of the car. The excessive fines clause arguably gives them some of that power, but typically, like the forfeiture statutes themselves basically say, if the state wants to take your car and they can check the box and show that you had a gram of weed in the car one time, or whatever the predicate crime is, then they get to sue and take your vehicle. So it does vest a lot of power in executive branch actors in a way that often gives them an incentive to maximize the amount of stuff they can take.
What percentage of these violations would you say is coming from the overreach of in the judicial system, of a judge actually going through that due process in a form of some type of a conviction for something that the person has then been found guilty of? And how much is it prior to actually having that and being from maybe an administrative agency of any kind, which has been delegated that power from the executive or the legislative branch?
Yeah, so I think kind of the most obvious examples of overreach come when the penalty is kind of like an on-off switch, when you're not talking about, oh, well, there's a range of monetary fines and the judge gets to make an educated decision and pick where he thinks you fit. Like there might be some outlier decisions there, but at least the judge is kind of exercising some discretion to try to figure out kind of where on the spectrum of wrongdoing you land. But the danger really comes when we're talking about forfeitures, when we're talking about penalties like the one the IRS imposed, where it really is just kind of like, well, did you violate this particular law? If so, you kind of get hit with a kind of a set punishment that doesn't necessarily bear any relationship to your level of culpability. So like, well, did you violate a low-level drug crime? Well, yes, okay, we're taking your car. It doesn't matter if it was a bicycle or a $1,000 beater or whether it's a $250,000 Bugatti, we're taking it. Doesn't matter what the value is. And it's in those kinds of cases where you really see the potential for just a really glaring mismatch between the seriousness of the crime versus the severity of the punishment.
Do you think that there is a issue with the way that our current government is interpreting property rights in general? Do you think that there's a larger that our founders had a more clear picture of property rights for the individual, or do you think that this issue is arising from somewhere else?
I guess that's kind of a broad question, but yes, there are certainly many instances where we think the Constitution should secure more vigorously people's property rights. So, for example, we litigated a case called Kelo versus New London back in the early 2000s, which involved Pfizer and the city of New London taking people's homes to replace them with nicer homes, and they said that was fine. We obviously disagree with that. And there's examples of civil forfeiture abuse and lots of other situations where our view is that it's a really big deal when the government wants to take your stuff, whether it's your cash, your home, your car, whatever. And it's a formidable power. And when the government wants to exercise that power, we should be skeptical of why they're doing it, of whether they're doing it correctly. And that's doubly true, I think, when the very government officials who are deciding whether to take your stuff stand to benefit, either personally or institutionally stand to benefit from doing so because the money goes right back to their agencies.
Do you think that that's one place legislatively that we could improve this, is if it wasn't going directly back into the same agency that was levying the penalty, or do you think that functions too well as almost like that we can then fund, and that then there's an incentive, almost like an economic driver within the agency?
Yeah, so I think there's definitely room for legislative reform there, and in fact, we've seen certain states reform their civil forfeiture laws, for example, to cut off that kind of link between the decision maker and the financial benefit, and that's really the way it should be. I guess at a surface level, there could be some appeal to saying, well, let's just let the police self-fund, so we don't have to tax people to pay for the police, but that has some pretty obvious concerns where then the police are always looking for more money to kind of keep their salaries so they can pay their mortgages, pay their kids' college tuition. And we don't want people exercising power over life and death and our property, who are exercising that power with an eye towards, well, we got to hit our budget this month. That's an obvious recipe for disaster.
Yeah. Do you think that there is if you're, as a lawyer, if you were trying to decide what is the gear in the system that would help for the most evenly distributed justice, as far as that there will be the least amount of excessive fines that do not commensurate with the actual justice being done, do you think that issue is in that it just needs to be that the people who are in these positions need to better discretion, or do you think that there's a legislative avenue or judicial avenue or something that should be addressed in order to reach that end?
Yeah.
Is there a solution?
Yeah, so I don't know if I have a kind of a global solution to all of that. I can give you kind of a couple of answers. One, as we were talking about, I think kind of severing the link between people who are deciding whether to take your stuff and profiting from doing it, like that's a critical thing to do. Like there's just an obvious kind of financial conflict of interest there that works to the detriment of the people whose stuff is being taken. Beyond that, I think there's a broader concern with courts giving kind of too much deference, whether that's to agencies or to legislators who are kind of passing these laws without necessarily thinking about the consequences of doing so. And so we like to urge in a lot of different contexts, we urge for what we call judicial engagement, which is where we have courts, looking at the facts on the ground, looking at the evidence in the record, and just figuring out, whether, some kind of law, for example, actually makes sense, whether the government can actually stand up in court and plausibly defend it rather than reflexively rubber stamping it and saying, well, you know what, we'll just leave it to some other branch of government.
I broke up at the end there, but I think I heard I think I heard your answer, which is it's interesting with all of these, when we go through the amendments and we basically end up hearing, okay, how's the amendment being violated today? And how is it stood up today? And, we get to really actually got into thinking, like, what if we didn't have this amendment? And it is important. I think that people would be surprised, though, that in some of these cases you're talking about, like we have talked about that. Like you said, New Holland case before, where there was houses taken for a Pfizer factory, and some of these things have come up in civil forfeiture, and certain things that you brought up, like with the penalty for the grandmother, with the IRS penalty. People, I think, certain people are paying attention, know this is going on, but I think that a lot of people, if you ask them, could this happen, they would say no. And I think I would be one of those people that would say, no, I don't think that can happen, because there's something that would stop that from happening. Do you think that, is that your observation too? Do you think that this is something most people know, the extent of what can be taken from someone?
I mean, but yes and no. I mean, I'll tell you that, a big part of the work that we do is not just litigating, in the courtroom, which is a lot of the work, but also litigating in what we call the court of public opinion. And the goal there is to do exactly what you're alluding to, namely, broaden people's awareness to realize that this kind of stuff is happening. And equally important, put a human face on the actual costs of what's going on. It takes, in my view, it takes kind of a lot of guts for our clients to stand up and, fight back against, their local government or their state AG or the IRS. Like, honestly, I don't know if I would have the guts to kind of do that myself. It's easier to just kind of be the lawyer. But really the only way that you're going to see change, and putting an end to these kinds of injustices is to have people who kind of, like, when the rubber meets the road, they're willing to spend years of their life going to court and sitting for depositions and having their story told on a nationwide level. In the hopes that ultimately the courts will recognize that something's gone horribly wrong, and either legislators or judges will see that justice is done.
Yeah, I mean, thank you for what you do. Honestly, it is it's total disenfranchisement if you have your life's work destroyed in front of you by your government, who you'd think would be there to protect you. Whether or not you've done something wrong, there is a natural law within the founding of our country that means that really punishment should be equal to justice, which would mean it should relate to the damage that was done by the guilty party and not excessively, or that's not justice. That's some form of revenge, or, like you're saying, the government enriching itself. So thank you for what you do. Kathy, is there some audience questions we should get to?
Yes, definitely. And Jewel, have we missed your birthday?
Yes, today is my birthday.
Well, happy birthday. We just mentioned Tova's birthday when she was on earlier. I didn't realize that you two had birthdays so close together, but happy birthday. And thank you for joining us on your birthday. And thank you for all your great questions. So, Sam, Robert Spiegler asks, if a prisoner thinks they're experiencing cruel and unusual punishment, what legal options do they have?
I'm probably not the best person to ask, since we typically don't represent prisoners in kind of prison conditions cases. So my first suggestion would be to talk to a lawyer who actually knows the answer to that. But I think at a broad level, prisoners have rights under the Constitution. Like, one of those rights is the 8th Amendment. They can file lawsuits to try to vindicate that right. The only other thing I would say is that there's something called the Prison Litigation Reform Act, which is the statute that, as I understand it, makes it difficult, or there's hoops that prisoners have to jump through. Typically, they have to exhaust various kind of internal prison bureaucracy avenues before they can actually file a lawsuit. And with that, I've literally said everything I know about that subject. So I urge your questioner to talk to someone who knows a bit more than I do about that.
Okay, great. And then Ed Brookoff asks, how does this amendment apply to what some may consider excessive pretrial imprisonment, or does it apply to this one at all?
Yeah, so my sense is not really. Like, the excessive bail clause, I guess theoretically could, if someone, if excessive bail prevents someone from kind of paying the money and getting out. My sense is that clause doesn't do a ton of work on the ground. The one other thing I would say is that, there's like various there's the Speedy Trial Act. I think the 6th Amendment, which you all may be more experts on than I am at this point, kind of theoretically provides for some kind of, speediness when it comes to going from like arrest to trial. But there's no question that kind of on the ground, people often spend months or years in prison, even when they might not have committed any crime. Part of that might be because they can't afford their bail, of course. Part of it might be because prosecutors know that by keeping someone in prison for a year pending trial, that creates an immense pressure on those people to plead guilty. I mean, that they don't have to go to trial at all. They may plead guilty to crimes they didn't actually commit, because that will put a felony on their record, but it'll let them go home today to their families. So there's no question that pretrial detention is a serious issue. I don't know how much the Eighth Amendment specifically can do to address those issues.
Well, thank you for that. And then Tracy asks, have you worked on any international cases involving civil forfeiture? For example, in the wake of war in Ukraine, could the U.S. seize Russian assets?
Yeah, so the short answer is that we have not been involved in any cases like that. Your question is right, that there is a whole bunch of forfeiture cases that involve freezing assets of kind of disfavored countries, or folks who are outside the borders of the United States. I guess the one example I'll give of kind of an internationally flavored forfeiture case that we were involved in was we represented a Christian rock band from, I think, Burma, although I may be getting the country wrong, who had a ton of their the money that they earned from their band tour seized by a sheriff in Oklahoma, who insisted that the money had to be drug proceeds. And so my colleagues, ended up representing them. Within a few hours, the sheriff had backed down and given the money back. And one of my colleagues had the chance to actually, fly to Asia and kind of hand deliver a check back to the orphanage that the rock band was raising money for. So it doesn't not actually responsive to the question, but it's kind of a cool story.
Yeah, that is interesting. That's very interesting. And then Eric Braverman asks if the concept of the Eighth Amendment comes from even a higher law than the English law that you cited. Do you think there's some biblical roots in the Eighth Amendment?
That might be kind of above my pay grade, but I would say, I suspect you could go back to Magna Carta. You'd probably find some roots there. A lot of what we saw in the 1689 Declaration of Rights kind of traces back to the Magna Carta. Honestly, I don't have a whole lot more to say on that, because I honestly don't really know.
Okay, and then Sharon asked, we have a lot of audience questions today. We're trying to get through a bunch of them here. Sharon asked, have you seen any cases involving cryptocurrency? Have you seen the government take possession? Because that's really in the news right now.
Yeah, so I can't point to any examples, but I can say, like, I get a Google alert every day for civil forfeiture articles, and there has certainly been a spike, I think, in kind of discussions around forfeiture and seizure of cryptocurrency. So if it's not a hot issue yet in the forfeiture world, I suspect that it will be in the relatively near future.
Okay, well, great. And then Susan Baker wants to wish Tova and Jewel a very happy birthday. And Aubrey, before we go, we really wanted to show your website and show our listeners a little bit more about what you do, because I think everybody has been very interested in that today, in these cases that you've litigated. Aubrey, can you pull up the Institute for Justice website? And then is there anything that you would want to particularly point us out to on the website that I'm sure y'all are taking donations for Giving Tuesday today, so we can certainly point people to give now if y'all like what you heard today and want to support Institute for Justice for Giving Tuesday. And any other thing that you would want to point out?
Yeah, no, I guess that was a good thing to point out. We're a nonprofit. We're a 501c3, so we run primarily on donations, though sometimes the government has to pay our attorneys' fees when we beat them. But yeah, I think it's actually a pretty good website, and I guess I would say that since I work here. But I'd encourage your listeners to check it out. Go to the case pages. I think what really sets apart a lot of our work is that we don't kind of hide our clients behind us. We're proud of our clients, we're proud of their stories, and so you'll see a lot of examples throughout the website that our clients are really just ordinary people who are put in really extraordinary situations, and really have kind of the gumption to stand up and stand beside us and let us work with them and partner with them to make, what's often kind of the worst experience of their life, a force for good and a force for securing justice for a lot of different people.
Thank you. And we want to invite everybody to be back with us next week for the 9th Amendment. And after that, we will be doing the 10th Amendment, and that will be right before Bill of Rights Day. And we do have our guest secured for the 10th Amendment. We're going to be having Jeff Skakanga, who heads up Ashbrook Center for the 10th Amendment. And we are going to be announcing our 9th Amendment guest really soon. So we thank everybody for joining us today. And thank you so much, Sam, for being with us. You just made some excellent points, and we really learned so much about the 8th Amendment that I think we all didn't know. So thank you. And we look forward to seeing everybody next week.